Today, we are going to dive into the official electronic publications of normative legal acts. It's a topic that's more fascinating than it sounds, I promise. This explainer is based on the works of Professor Vehar Kiskanov. So, here's our roadmap. First, we'll take a quick trip through the history of legal media. Then, we'll zoom in on how the European Union made the big switch to digital. After that, we'll get into the nitty-gritty of the regulations, tackle the tricky issue of consolidation, compare the EU and Bulgarian systems, and finally, we'll look ahead to the future of digital law. All right, first things first, to really understand just how big a deal today's digital laws are, we've got to look back at how we got here. You know, for thousands of years, the way we've recorded and shared our laws has been constantly changing. Just look at this journey. We started by carving laws into stone. Think Hammurabi's Code, making them permanent, public. The Romans, well, they used bronze for their 12 tables. Then came papyrus, and eventually paper, which, thanks to Gutenberg's printing press, completely changed the game for spreading legal texts. Each step made the law more durable, easier to get, or more efficient. And that brings us to today, the age of the computer and the internet, with amazing resources like the EU's EUR-Lex. And this all leads to a really fundamental question. When we go from a physical thing, like a stone tablet or a book, to a digital file, does that change the law itself? I mean, does it alter how we write it, how we read it, and how we think about it? Let's keep that question in the back of our minds. Okay, let's turn to our main case study here, the European Union. We're going to look at its massive shift over to legally binding electronic publications. Now, this is where it gets really interesting. For 15 years, think about that, from 1998 to 2013, the EU's official journal was online. Everybody was using it, citizens, lawyers, courts, you name it. But legally, the only thing that mattered was the printed paper version. The online version, it was just a helpful but unofficial copy, a huge disconnect between practice and law.
So what pushed them to make a change? Well, for one, it was just plain inconvenient. Imagine doing all your research online, but then having to track down a paper copy to cite in court. There was also a bigger principle at play: fairness. Everyone in the EU should be able to access the law at the exact same time. And of course, there was the money. An annual subscription to the paper journal costs €1,400. It all fed into the bigger picture of the digital agenda for Europe.
And that brings us to the solution: a real landmark regulation that finally pulled EU law firmly into the 21st century. 2013. This is the year. This is when everything changed. On July 1st, a new regulation kicked in, and with it, a whole new legal reality for the entire European Union. So the absolute key idea here is the authentic electronic publication. This means the digital version of the official journal isn't just a copy anymore, it is the law. And its authenticity, that's guaranteed by an advanced electronic signature. Think of it as a high-tech seal that proves the document is the real deal and hasn't been messed with.
And things keep getting refined. You see, before this year, 2024, if the whole digital system crashed, the law actually reverted back to the old printed version. But a really important update just changed that. Now, if there's a system failure, the print version is only authentic for a little while. The second the system is back online, the digital version immediately becomes the one and only definitive legal source. Digital is officially king. Okay, so we've established the digital official journal is authentic. But this opens up another can of worms, really. What do you do with laws that have been amended and changed over the years? This is where the Consolidated Act comes in. Just think of it as the most current, all-in-one version of a law. It takes the original text and neatly weaves in every single amendment and correction. It's incredibly handy for anyone who just wants to know what the law says right now. And this shows the problem perfectly. You've got the original law, then Amendment A comes along, then Amendment B. The consolidated version helpfully puts it all together for you, but, and this is the part you absolutely have to remember, that convenient, easy-to-read version has zero legal force. It's for reference only. If a court needs to decide something, they have to go back to the individual officially published documents. It's a convenient truth, but it's not the legally binding one. Now, this digital shift isn't happening the same way everywhere. Let's do a quick comparison between the EU's approach and a specific member state, Bulgaria, to see how different the systems can be. This table really spells it out. For the EU, the electronic version is the authentic one, period. It takes precedence. But in Bulgaria, while the stake gazette is online, the law still says that if there's a conflict between the online and print versions, the printed text is what counts. And for both, those super helpful consolidated versions are still unofficial. This really highlights a key point. For Bulgarian law to keep pace, the next logical step would be to give full legal force to the electronic stake gazette, just like the EU did. So let's zoom out for a second and think about the bigger picture. This whole transition from paper to pixels, well, it raises some really deep questions about what law even is in our society today.
So what's next on the to-do list? Well, we need to formally define what this new official form of digital law even looks like. A huge goal is to figure out how to make those consolidated versions legally binding, so the most current law is also the official one. This also makes us rethink that old saying, ignorance of the law is no excuse, right? If the entire body of law is just a click away, what does that mean for our duty to know it? And, maybe most importantly, how do we make absolutely sure that access is free and available to every single citizen? And this quote from Professor Kiskanov's work just nails it. We aren't just scanning old documents here. We're creating a completely new form of law, and our legal systems have to catch up and build a proper framework around it. So we've gone on this incredible journey from laws carved in stone to laws stored in the cloud. The goal has always been the same, to make justice more lasting, more accessible, more efficient. But as we get closer than ever to universal access, it leaves us with one last big thought to chew on. What is our responsibility as citizens to actually engage with and understand the laws that shape our lives?